the chairman of the Bar Council of Andhra Pradesh, Shri Dwarakanath Reddy, Vice Chairman, Sir Krishna Mohan, my former colleague on the disciplinary committee, Mr. Ganta Ramarao, my dear friends, Bar Council members, learned advocates, professors, law students, ladies and gentlemen. This is a great opportunity for me to be amongst you, especially post-retirement. People like me yearn for this kind of an opportunity because your very presence itself has the effect of recharging the spirits. So I profoundly thank the Bar Council, led by its ebullient chairman, Mr. Dwarakanath Reddy, for giving me this opportunity of being before you. When the chairman, Mr. Dwarakanath Reddy, requested me to spare a session, giving me the freedom of choosing the topic, after pondering over for a while, I thought I should address on the topic, the art of advocacy. The reason I chose this topic is that it has eternal importance and perennial relevance. Art of advocacy is the bread and butter of every practicing advocate. Without an advocate perfecting that art, he may earn money, but he cannot earn the fame of being a good or outstanding advocate. We keep, in fact, in my experience, I used to hear certain comments about some advocates. There were very notable advocates among them, but I don't want to name them. A counsel, when he is asked by somebody whether he has a point in the case, he says, I have no point in my case, but the opposite counsel is my strength. That means what? A counsel appearing against him is a self-goal master. Not because he is not knowledgeable, not because he is not competent, but because he lacks the art of advocacy. He will not put forth his point as per the mood of the judge. He will not stress a point which ought to be stressed. He will overemphasize a point which does not require such overemphasis. So, as a result of all this, because of the lack of advocacy, he will allow the other side to have better of him. So, this is the kind of importance which advocacy plays its role in the professional life of every advocate. When we hear the word of advocacy, we generally feel that it's a misconception, if I rather say, that advocacy starts only in court and ends in court. In my personal view, that may not be correct. Advocacy starts from the time of one's enrollment. It starts with the advocate choosing his chambers or office. We keep hearing about the pedigree. You know what pedigree is? It is generally referred to dogs. Before we buy a puppy, we inquire its pedigree. What is its father? What is its mother? What is its breed? What kind of nature it has? Whether it is savage, whether it is friendly, so on and so forth. Before we bet on a horse, we inquire about from which stable the horse comes. The great lawyer Mr. Fali Nariman, in his book, Before Memory Fades, he refers to this exact point. Before you choose the chambers of senior, you should know about his pedigree. You should know about the traditions the office follows, the culture, the working culture, the environment, all that matters. Because finally, it is the fragrance of the goodness of that office which pervades you, at least during the initial professional days, your initial professional days. And it is the stench of the bad office which haunts you. Because I kept hearing during my practicing days that if somebody, even out of mistake, makes a misstatement of fact, and incidentally he came from not so an office which, from an office which doesn't have a great reputation, people used to call, what else it is expected from him except this misrepresentation. So this is how I say that the stench emanated from the bad office always haunts you in your professional days. You may be a very good lawyer, but you will not be trusted. So the first and foremost step, I hope there are budding lawyers, there are also law students. This is very much relevant for them to know that you need to choose a good office. Good office need not necessarily be a very rich office. An office which adopts best practices in profession. An office which has proper culture, environment, working culture. All this make an office a good office. So one has to be very choosy in selecting the office. Once you get into the office, you have to learn, and there is no end for learning. In fact, I for one, in my initial days, when I was with my first senior, Mr. R. Venugopal Reddy, who later became Advocate General, he had a peculiar habit of starting his office at 8:30 or 9 p.m. We, the juniors, used to go to the office at around 7:30 after finishing early dinner. Then finish whatever work he has assigned to us and wait for his arrival. We used to keep our drafts ready for his perusal. So he used to call the juniors one by one. By the time he finishes with all the juniors, it will be around 11 to 11:30 night. Then by the time we reach our home, it will be around 12. Then again, by 8 o'clock, we should be in the office. So this is the kind of commitment with which we worked in his office. And I should say that if I'm standing before you today, it is only because of that hard learning I had in his office for 5 years that made me stand in my profession. Of course, I should not forget my later senior, Mr. V.R. Reddy, who also became Advocate General later, who gave me immense opportunities to represent the cases, to get that kind of exposure. All that exposure I could only because of my hard work I have put in during the initial 5 years period. And when it comes to learning, the younger generation may not know what kind of hard work we used to put in. I should say it's a donkey's job. Donkey's job because we never used to have the advantage of this information technology. If we are to look for legal position and pick out any decisions, we needed to consult digests, annual digests, that is called yearly digests, biennial digests, 5 years digest, decennial digest, quinquennial digest, whatnot. So we had to dust all those digests and keep on turning the pages topic-wise. And if at long last we are able to get one judgment relevant, and to our disappointment, we used to find that was already overruled. So this was the kind of learning or the method of learning we went through. But today, sorry, please don't. But today, just by a click of the button, you will get all the decisions, including overruled decisions. So it has become, your job has become so very easy that in a time of 1 hour or 2 hours, you can have the entire legal position in your grip. So this is the great advantage you have in learning. Please don't allow this kind of opportunities to fritter away. So learning is very, very important. And during the course of learning, you should win the confidence of your senior. That's very important. There may be 10 juniors in an office, but the senior will not trust all 10. He will only trust only those who put in real hard work and who will be of use to him. That you should remember. So you should always be ready to assist your senior. You should win his confidence so that he will give you more and more opportunities to represent in the court. Then, once you become independent, you have to deal with your clients. How do you deal with your client? That is also a part of art of advocacy. I know of advocates who are very rough with the clients. I know of some advocates who used to throw the files on the faces of the clients. I know of the advocates who never shares anything with the client. These are all bad examples. After all, the client is your paymaster. As Gandhiji said, the customer is your god. The client is your god. You owe your existence to the client. Without client, you are not there. There is no profession. That we should remember. But unfortunately, at least some of the advocates, if not all, some are very courteous, no doubt, treat the clients in a very rough manner. Please, one should not do that. Justice Kodandaramaiah, if I remember correctly, I read some 30 years back, a book written by him on professional ethics. He said, please always remember, your client is going to be your potential adversary. Your client will be your potential, maybe your potential adversary, because we have been seeing hundreds of cases being filed against the advocates by the clients before the Bar Council. That's what he really meant. So we should always keep in mind that the client is your valued customer. You should always be good with him. Then you have to share before you accept the brief, you have to share the probability of success with the client, your opinion. Of course, you should never be judgmental, because you are not a judge to judge what will be the final outcome of the case. But you should always give a hint to the client whether there is any possibility of success, whether it is a strong case or weak case. If you feel it is a weak case, you have to tell the client that you have to take the risk. Then ultimately it is for the client to decide whether to file the case or not to file the case. In fact, up to one stage, I used to commit a very fundamental mistake of turning away the client, saying that this is a weak case, in spite of his request that I should file cases. Finally, he will land up in some other advocate's office, he will file it, and I found to my amusement that he could even get stay in those cases, interim orders in those cases. So we should not be judgmental, but at the same time, we have to tell the client about the prospects of his success in the case, and then you have to leave it to the wish of the client to file the case or not to file the case. Another important aspect is charging the fees. How will you charge the fees? Some advocates, at least if not all, I wish advocate fees rules are followed. Some of the advocates will not touch the file unless fees is fixed. According to me, it's a bad practice. You should never turn away your client based on fees. The reason being, I will tell you the reason also. There is always what is called cross-subsidization. There may be a case where there will be windfall for an advocate without putting much efforts. There may be another case where you struggle a lot, you prepare a lot, you make all out efforts, but you may not be able to get proper fees. But what is earned by you in the first case, wherein you have not put in much efforts, will compensate for the case where you did not charge proper fees. I'll recount my own experience in this regard. I was standing counsel for Electricity Board, AP State Electricity Board. Water. I used to have many cases for the entire combined Andhra Pradesh. All non-service matters used to be looked after by me. Sorry. And compared to today's level of fees, it was a pittance. If it is a writ petition, we used to get 250 rupees per writ petition. And in batch cases, for first case 250 rupees, and in other cases 100 rupees. A huge matter involving, I can say those days itself, about 1,000 crores. I'm talking about 1990. That subject related to categorization of consumers. A new category was formed, that is called power intensive category among the industrial consumers. That was challenged. AP Ferroalloys Corporation was the leading client, Navabharat Ferroalloys Corporation, and two other companies. There were huge industries paying at least 15 to 20 crores towards electricity charges those days. Because for ferroalloys industry, electricity is the raw material. So I was a temporary standing counsel for some time, and then on completion of my 10 years of standing, my fortune could have it. I was appointed as standing counsel for APS State Electricity Board, youngest standing counsel. And Chief Justice Majmudar, a saintly judge, was the presiding judge, and he didn't know me. I can say, at the age of, with 10 years standing, for a new Chief Justice coming from outside, I was a non-entity. So, on the other side, my adversary was Mr. Ananta Babu. Ananta Babu was standing counsel for APSCB for 25 years. And then after ceasing to be standing counsel, he started filing cases against APSCB. So that was the advantage for him, and his personality, overwhelming personality, great personality. Then the case was heard. For 2.5 days, Mr. Ananta Babu argued, supported by Mr. Koka Srinivas Murthy, another stalwart. And of course, Mr. M.R.K. Chowdhury was also there. And then, when I started my argument, Justice Majumdar did not allow me to speak even for half an hour. I had to face volley of questions. So I had to swallow all that, and then slowly made my way through. And I took about 1.5 days to finally convince the court. They totally tilted in my favor. Then, in the reply, you know what Mr. Ananta Babu started? He had great felicity of expression. My lord, my young learned friend, with all his resilience, picked up something from my argument and something from your lordship's observations, and knitted a great case which has absolutely no substance. This is how he started his reply. And that showed his frustration, because he knew that the bench was totally in my favor, leaned to my favor. A bench which was totally against me, completely leaned in my favor. Finally, I succeeded. It's a reported judgment. I think AR 1990 AP Ferroalloys Corporation versus AP State Electricity Board. Ferroalloys Corporation, FACR, not AP. Ferroalloys Corporation versus AP State Electricity Board. The bench consisting of Chief Justice Majmudar and Justice Bhaskar Rao. A. Bhaskar Rao. Y. Bhaskar Rao. And the real essence in this story is, I had to charge my fees. How much I charge? The kind of efforts I have put in, you can't believe. For almost 1 month, I lost my sleep. Because on the one side, there are stalwarts, advocates, and the case is inherently weak, I should tell you. It is inherently weak. Every day, I used to call my chief engineer, superintending engineer, DE to my office. After completing my initial work, I used to sit with them every day for 1 hour, 1.5 hours. We dug into the record. I tried to make a case, a new case, in order to justify this classification, which, in my personal opinion, was absolutely not justified. There was no justification at all. But as a lawyer, I had to my duty. So, with the kind of effort I have put in, I thought any amount of fees will not justify the efforts I have made. And how, if I make a claim, how much I claim? By the time it was 500 rupees for writ petition. For first writ petition, 500. Next 3 cases, 250, 250, 250. 750, 1250 rupees. Even if somebody pays me 5 lakhs of rupees, that would not be worth the efforts I have made. You know what I said? I refuse to claim fees. I have not claimed fees. I have not received fees in that case. But that I always etched in my memory that case. It is invaluable. I may not have received the fees, but it is such an invaluable thing. There, you know how I got myself reconciled. After all, the same SCB, APSCB is paying me fees in various other cases. That would definitely compensate for what I have lost in this case. This is how I reconciled myself. That's why I said, never ever turn away your client only because he is not paying you the kind of fees you propose to charge or you quoted before your client. This is why I have recounted my experience. So this is one aspect. Then I also want to share an anecdote on this, the unreasonableness of fees. There were two brothers. As usual, they fought for property. So a partition suit was to be filed. So it was a composite Madras state. So jurisdiction being a presidential high court, the Madras High Court used to have original jurisdiction. So one brother went to a lawyer. He was taken rather by some middleman to a big lawyer in Madras. Then the lawyer, after studying the entire case, he quoted a particular fees. Then this man was astonished, shocked. Then he slowly told the lawyer, "Sir, my father tells me that we are only two brothers." Means you are claiming a third share, 1/3 share towards fees. This is not a story. This is actually what has happened. A lawyer who knew this personally told us. So, of course, now I don't want to comment anything about the kind of exorbitant fees many advocates are charging, especially in Supreme Court. And I don't think a common man can afford to indulge in litigation. It's a different matter. As somebody said, advocates' fees rules. That's why I said I wish they charge as per advocates' fees rules. Nobody is just even looking into advocates' fees rules. Leave aside following them. Then, preparation of the case. Next stage is preparation of case. How will you prepare for the case? You know, the initial step is understanding the facts of the case, then application of law to the facts of the case, and then start drafting your pleadings. How will you draft the pleadings? Of course, if you go to solicitor's office, he will draft 100 or 150 pages pleadings, making repetition, and copiously referring to entire case law, whatever knowledge he has of the case law. According to me, that is not the way of preparation of pleadings. One should remember that the pleadings are being spoken by the parties, not by the advocates. So somehow we have to step into the shoes of the party and then start writing the pleading. Most of the parties may not be knowing anything about law, so why should they state about law? Leave alone citing judgments. So the pleadings must be such that they must be comprehensive on facts. If necessary, you can broadly indicate the legal position. That is all the pleadings about. But all fundamental facts must be stated, because tomorrow you may not be allowed to amend the pleadings, especially in civil suits. Courts are very strict nowadays, even to allow amendments. So, you must be comprehensive on the facts of the case. You may or may not indicate the legal position also, because it is the job of the advocate to present to service the legal position. In fact, if you write pleadings running to pages, Judges may not have the patience to read all that. That may be counterproductive also. There used to be an advocate, even now he is practicing. He is a designated senior advocate. He used to file cases, writ petitions in electricity matters. His affidavits used to run to about 40 to 50 pages with countless number of grounds in the affidavit itself. It was a challenge for me to draft a counter affidavit because the affidavit was replete with repetitions. So after going through the affidavit for some time, for some length, we give up and we write whatever is necessary for our counter and file it. He is so agile. During the hearing, he will say, "My lord, my ground number H is not adverted to in the counter. That means it is deemed to be admitted." So this kind of, it also creates problems to the other side. It's an unfair problem. So, and I know of two advocates, illustrious advocates I can say, and they have adorned the bench, both of them. Their affidavits never used to, exceed 3 pages. And one among them, a constitutional expert, would not even state the facts. He will say, "What is there? I can plead the facts in the court." But according to me, with due respect to them, that is also not the way of preparing pleadings. You must state the essence of your client's case. And all the facts which are relevant for the purpose of the case have to be necessarily stated in the affidavit. You should be luminous. You should be luminous, but not voluminous. Remember it. You should be luminous, but not voluminous. By mere volume, you will not improve the case. But at the same time, you should be luminously stating the essence of your client's case. That's very important. So, follow the middle path. Don't run to 50 pages. Don't restrict to 3 pages. It is not the volume that is important. It is finally the quality of the pleadings which is very important. That should always be remembered. So this is all part of advocacy. Then, after pleadings, what comes? Presentation. Presentation is such an important thing. At home, you may think of advancing very great arguments. When it comes to your performance, you may not reach even 50% of your expectations. In this regard, I would like to refer to a great person, Robert H. Jackson. Robert H. Jackson, in 1930s, he was a Solicitor General of United States of America, who later became Associate Judge. He has put in very humorously how presentation would be. Such a great man, not an ordinary person, great personality. He said, "I always made 3 arguments in every case." This is what he said. "I always made 3 arguments in every case. The one planned." The first argument is one planned. You plan. Second, the one presented. The one planned at home. Then the one presented at court. And it consists of what? The arguments which are presented consists of what? Illogical, incoherent, and incomplete. Illogical, incoherent, and incomplete. This is how one presents. And then the third argument remains. When is that argument made? When he goes to bed. At the bedtime, he advances utterly devastating argument he thought of presenting in the court. See how beautifully he has put it. The kind of difficulty in presenting the argument is so lucidly explained by him in such a humorous manner. So this is absolutely true. In fact, in my own experience, I must have come across these situations many a time. I may feel that I'll rip away, I'll rip through the whole thing. I'll convince the judge this and that. Finally, I may not be able to achieve the output of 50% of what I thought. So your effort is to bridge that gap or reduce that gap between what you plan and what you presented. Then only you will become a very successful lawyer. Then you have to cite case law. You should be abreast of case law. Without application of case law to the facts of the case, you will not be able to succeed. But how much case law you cite is another question. We see many advocates, in fact, in nowadays, I don't know what is happening now. They put the judgments in final hearing matters from left to right, maybe 20, 25 volumes, and it will really scare the judge. Sometimes some judges try to avoid hearing that case also, seeing the voluminous of cases. And then the advocate picks up each judgment, start reading head note and say, no, my lord, this is not relevant, keeps it aside. Then again, take another volume, read something, no, this may not be very much of relevance. Finally, out of those 25 books, he may be citing 2 or 3 relevant judgments, if at all, at the best. Why scare the judge? So this is called the case diarrhea. Case diarrhea. Don't suffer from that. Mr. Nariman, in his book Before Memory Fades, you have to read that book. Before Memory Fades. Nariman's book is called Before Memory Fades. He says, don't suffer from case diarrhea. Case law diarrhea, sorry. Case law diarrhea. Too much of case law leads to diarrhea. That's not good. That will irk the judge. See, in the process, you know, Nanna Pulivache. See, if you cite 10 unimportant judgments, and later if you cite 1 important judgment, the judge will ignore that important judgment also. So that will lose its significance. So don't suffer from case law diarrhea. Cite relevant cases. And there is another important aspect, most important aspect. If you have 5 points in a case, which point you argue first? What, Mr. Nagireddy, which point you argue first? Huh? Loud. No. If you have 5 points, you may have best point, you may have not so good point, you may have bad point. Which point you argue? All right. Emma, which point you argue? Will you put forth the best point first or reserve it later? Huh? Best point at first. But there was an interesting conversation between Lord Hailsham of Marylebone. Lord Hailsham of Marylebone. He was a member of House of Lords. And Wilfred Green, MR. Wilfred Green, a very celebrated judge of Court of Appeal. MR means Master of Rolls. A presiding judge of Court of Appeal in England used to be called MR. So there was an interesting conversation when they met one day. Mr. Green, Justice Green has asked this Lord Hailsham of Marylebone, which point you argue? He said, of course, best point. He said, no. You should argue the weakest point first. He says, see, if you start arguing weakest point, the judge will ask you, no, Mr. Gentleman, no, you go to next point. All right, next point is also not that good. All right, go to next point. Next point is also not good. Already, finally, you come to the best point. And you should not, he says, you should not assert that this is the best point. You should, with pretended hesitancy, say, my lord, I have this point. then the judge will, if he is sensible, he will pick it up and he will start arguing for the counsel. Yes, this is the best point. Yes, my lord, I am obliged to your lordships. So this is how, after all, these are all perceptions. See, you may be right also, because it all depends upon the judge. Because if there is an impatient judge, if you put forth all your bad points, weak points first, then he will not consider the best point also. So it's a double-edged weapon, no doubt. But see, these are the two celebrated personalities between whom this discussion has taken place. So perceptions vary. You have to finally play by the ear. This is the most important aspect. See, nobody will teach you the absolute art of advocacy, I am telling you. These are all tips out of your own experience, your intelligence, your legal acumen, your common sense. You have to finally build your case. And there are many times when we innovate our arguments on feet. Even most of you who are active practitioners must have experienced it. Certain points which we never thought of in our chambers. Suddenly, those points crop up in the court when you argue. That is called developing the argument on feet. So, this is, I can say, this comes by your inherent nature, your experience, your wisdom, so many things. So, these are all, whatever I am saying, are basic things of advocacy. Then it all depends upon you, how to improve upon it. So, then, if a judge is not with you, what will you do? No point in persisting. No point in persisting with it. All right, you go to the next point. And if he is with you, it's all right. You can abandon the first point. If he is not with you on the second point, go to the third point. Go to the final point. Finally, you can say, my lord, I would like to press the first point again. Maybe there may be change of mind in the judge's mind. So, this is again part of art of advocacy. Then, always try to be polite. Never question the wisdom of the judges, because that will be rubbing the judge on wrong side. A judge may be wise, he may not be that wise. I don't want to use any derogatory words also. So all that you have good, bad, and indifferent judges. See, like a king is always right. King does no wrong. A judge does no wrong. So long as you are in his court, he is always right. So whatever he says, don't question him. But at the same time, don't be meek and weak. Put forth your point with assertion also, nothing wrong. But don't be disrespectful. Don't question the wisdom. And when a judge asks you to clarify on a point, bad habit for many advocates is, I'll come to that a little later, my lord. I'll come to that a little later. That will definitely irk the judge. And it will create an impression in the mind of the judge that you are going to avoid answering the judge. Never ever say that. Whenever a clarification is sought, it is your obligation and responsibility and duty to clarify to the judge as and when he puts you that question. And some advocates will be there who is habituated to say, if some proposition comes from the judge, he says, I never heard such a proposition. In my experience, I never experienced this. All that will be counterproductive. Avoid saying that. Avoid confrontation. He may be a bad judge, but doesn't matter, because the power of pen is with him, not with you. What will you do? If you exceed your limits, you will be attracting contempt. Of course, there are some advocates who thrive on belligerence. They always question the judge. They always try to bully the judge. They are called bullies. And they mount personal attack on judges. Mr. Nariman, in his book, said once he severely attacked the opposite counsel by name Kirit Rawal, the then additional Solicitor General. He was very unfair in mounting attack on him. The other side counsel, Mr. Kirit Rawal, did not utter a word. He did not even respond. Justice R.C. Lahoti, the then Chief Justice of India, he was hearing the case. He was presiding over the bench. He said, Mr. Nariman, it is time for you to stop practice. You are very unfair in your attack. It is time for you to stop practice. You know, Mr. Nariman said, he acknowledged R.C. Lahoti's comment and said, I am thankful for Justice Lahoti for making that comment because I was so unfair to the other side counsel. So he says, never ever join issue with the other side counsel. Always be respectful to the other side counsel. I have seen many advocates who always used to look at the other side while submitting their arguments. They seldom look at the judge. He always looks at the other side. And there are some advocates who, at the end of every sentence, look at the gallery, playing to the gallery. See, these are all very, very unhealthy practices. And maybe by bullying, one may make some short-term gain, but in the long run, no judge will like such people. When I was the judge, there were some advocates who were very, very quarrelsome, and judges used to be afraid of them. And you know, without offending anybody, I would say that one advocate for 17 judges said, not before me, against one advocate. 17 judges. And most of those cases used to be posted before me. Of course, I never had any trouble. With them. I knew how to deal with them, and they were also acknowledging it. And one advocate went to the extent of saying in open court, that troublesome advocate, that if your lordships doesn't do justice, nobody else will do justice. First, we should know how to deal with, and he was commenting privately that, see, I am trying to somehow corner this judge. He is such a smart judge. He never got caught. He did not give me that opportunity at all. So, of course, all judges may not have that kind of attitude. That's a different matter. We can't blame them. But in the first place, the advocates have no business to behave like that. After all, you have come here, you are a professional. You are a professional. You are not here to settle score with the judges. See, if you hit your head against wall, will wall break or your head break? Same thing. Howsoever weak the judge may be, you can't fight with him. Why should you fight? That is not your job. Your job is to fight for the client, not to fight against the judge. This is the fundamental thing a lawyer should always remember. You may have many issues, but that doesn't matter. When you are in the court, you should always be respectful. By being respectful, you will gain everything, but not lose anything. Whereas, by being offensive and rough, you lose everything. You lose not only the case, you lose the judge also. So that you should be very, very careful about. then you are an officer of the court, that everybody knows. When it comes to assisting the court, you should always be fair to the court. Your duty is first to the court, then only to your client. See, I had a very piquant situation. I was arguing a land acquisition appeal before a division bench. That was a case where, based on the oral evidence, certain compensation was fixed, ignoring the sale deeds. One of the parties to the sale deeds came before the court and deposed that no doubt a particular consideration is mentioned in the sale deed, but it is not that consideration. I have paid much more, which is in fact, generally it happens. Only for registration value, lesser value is shown, and the party always pays higher money. So he said, instead of 50,000, for example, I paid 1 lakh per acre, so take 1 lakh as the value. Then the lower court has taken 1 lakh and fixed compensation. The government filed appeals. It was a huge batch of appeals from Mahbubnagar. Then I was appearing for the farmers who lost the land in Priyadarshini Jurala project. Then the division bench, very intelligently, the presiding judge asked me, Mr. Reddy, please tell us whether oral evidence can exclude the documentary evidence. Then I don't know what to say, because I had to say it cannot be. But if I say that directly, then I'll be losing. My client will lose a lot of money, huge money. Then I said, and he said, I know about your fairness. I'll give you some time. You examine the legal position and place all the judgments before me. Then I went back. I have picked up at least half a dozen judgments, including the judgments of Privy Council, which refer to Section 91 of the Indian Evidence Act, which says that oral evidence is not admissible to displace the terms of documentary evidence, the terms in the document. Exclusion of oral evidence is the caption of Section 91 of the Indian Evidence Act. Then I placed all those judgments before the division bench. And I said, see, every recital in a document, in a sale deed, will not constitute term, but the quantum of consideration definitely constitutes a term. One can say a person who received who is shown to have received consideration in the document can come into the box and say that I have not received compensation, and that is admissible. Whereas, if he admits receiving compensation, he cannot say, I have not received 50,000, I have received 1 lakh. He cannot say that, because the quantum of consideration constitutes the term of the document. So the term cannot be replaced by oral evidence, is the proposition, legal proposition. So I cited half a dozen judgments against myself. The result is, my client has lost 50% of the compensation. But I have won the confidence of the judge. As a lawyer, I have won the confidence of the judge, though some loss is caused to my client. That's why you should always be fair to the court first, before you are fair to your client. Then, finally, I will come to the concluding part, because we can go on and on, but there is always a time constraint. See, never be humorous in the court, always be serious. But there may be instances where, when the court is very serious, the proceedings are very serious, you can certainly lighten up by certain mild humor. But Mr. Nariman again said, you should always be careful when you deal with the court. You will be dealing with the fire. So don't cross your limits in humor. Because after all, everybody will not be like Mr. G. Ramaswamy. I don't know how many of you have heard Mr. G. Ramaswamy. He was Attorney General of India. And he used to crack any joke and get away. One day, in Supreme Court, he was advancing a very ridiculous proposition. Very ridiculous. The presiding judge asked him, Mr. Ramaswamy, do you feel we are fools to accept this proposition? Pat came the reply, my lord, I am put in a quandary. If I say yes, I will be committing contempt. If I say no, I will be committing perjury. But how many of you can get away with this kind of humor? And this happened about 15 years back. I don't know what the present state of the affairs in the courts. I don't know. But everybody cannot be like Ramaswamy. And one more little anecdote. See, I think it's Ramaswamy somebody. The SLPs were being heard. A subject wagering contract cropped up in a case. The judge asked a very smart counsel, Mr. So-and-so, can you give me an example of wagering contract? He said, SLP, my lord. So these are all humor which most of the judges may not take it lightly. So we should be very careful about it. So these are all a few aspects of art of advocacy which I wanted to share with you. And there are many, many more aspects which could be discussed maybe at a different time. So finally, before I conclude, I once again thank all of you for patient hearing, and once again thank Mr. Dwarakanath Reddy and his team for giving me this opportunity. Thank you.